Determining terms. The parole evidence rule. Under the parole evidence rule, evidence that is extrinsic to a written contract is inadmissible to supplement or contradict the written contract. This applies if the contract is a complete integration, which means parties must intend that the contract to express their final agreement. Existence of merger clause can be a factor in showing an agreement is integrated, but is not dispositive. The parole evidence rule bars evidence of negotiations and agreements before contract becomes integrated. Exceptions are when the extrinsic evidence may be allowed if either contract was partially integrated or additional terms would ordinarily be in a separate agreement. Parole evidence rule allows evidence of mistake in the process of reducing an agreement in writing, misrepresentation, fraud, duress, or illegality, condition precedent to agreement becoming effective, modifications, whether oral or written, made after the writing, meaning parties intended to give particular terms in the writing. UCC, a written contract's terms may be explained or supplemented by evidence of course of dealing, performance, or trade, can be used to show parties' customs and precedence over an industry custom or trade. In any contract, express contract terms generally carry greater weight than extrinsic evidence. When we consider the delivery and loss of risk in a UCC contract, under the UCC contract, risk of loss issues arise when goods are lost or destroyed. Shipment by carrier, like FedEx, a contract type determines risk of loss. Shipment contracts, seller only obligated to ship goods to buyer. The risk of loss passes to the buyer when the seller delivers goods to the carrier. If contract is otherwise silent on the shipment terms, shipment contract is presumed if contract requires shipment by third-party carrier. Destination contracts, the seller is obligated to ensure goods reach buyer. The risk of loss passes to the buyer only when the buyer takes delivery. In a non-carrier delivery, goods not shipped by a common carrier, we got a merchant seller. The risk of loss is passed to the buyer when he takes physical possession. In a non-merchant seller, risk of loss passes to the buyer upon tender of delivery. Goods destroyed before risk of loss passes, contract is avoided if no party is at fault. Warranties and UCC implied warranties. A warranty is a promise regarding a contract. UCC contracts have default implied warranties which can be disclaimed. An express warranty is a promise about the quality or feature of a product. Manufacturer claims a cell phone is waterproof to 20 feet, breached if the product falls short of the seller's promise or description. An implied warrant of merchantability is when the seller automatically warrants goods are fit for their ordinary purpose. Implied warranty of fitness for a particular purpose is when the seller warrants that goods are fit for the buyer's purposes if 1, the buyer has a particular purpose, 2, buyer relies on seller to select suitable goods, and 3, seller has a reason to know of buyer's purpose and reliance on the seller. Limiting warranty liability. Contract can limit liability for warranties. A disclaimer limits liability for implied warranties with as is or with all faults language is enforceable. Disclaimers will not limit liability for express warranties. The remedy limitation limits recovery upon breach of warranty, generally valid for all warranties. Damages for breach. Generally, damages amount to the difference between the current value and value as warranted by the seller.